Thank you, Carissa. And Carissa forgot to introduce herself. Do you want to do that real quick, Carissa?
Sure. Yeah, I'm Carissa. I'm one of the legal advocates with the team here.
Thank you so much. All right, I'm going to say thank you and welcome again to everyone who has joined us. We really appreciate the chance to come together in community, even through this virtual platform. I don't think I have to tell anyone this has been a year of change and surprises and learning how to do new things. And POTS has been offering these community workshops to try to help make sure that we're sharing what we're learning with other members of the community and getting feedback from them as well. So we've done these workshops about every 3 months, and we're going to try to continue them for as long as they're useful. Some of this may be a repeat from past workshops, since we're now a year and a half into this pandemic. But as Carissa mentioned, we'll leave time for questions at the end. And if you have any questions, please put them in the chat as we go, and we'll try to address them if there's things that are on your mind as we're going. So just to start, there's been a lot of changes impacting on housing court and possible evictions during this pandemic. So we just thought it would make sense to do a quick overview about what some of those things have been. There's been a lot of change recently as well. So we're going to cover basically how housing court has been operating since the pandemic, and then go into the hardship declaration forms and EREP applications, which may be something that virtually everyone on this meeting is familiar with, but we just want to make sure people understand what they are and how to make use of them if they're not familiar to you yet. Okay, next slide. All right, so this is just a short summary of what happened in 2020. COVID was with us before we, I think, realized that it was with us. And in New York State, the state of emergency that was declared was on March 7th, 2020. In New York City, actually had the first eviction moratorium starting on March 16th, 1 week before the state moratorium. So up until March 13th, evictions were happening, as many of us who've been practicing for a while were familiar with. And then all of a sudden, everything shut down on March 16th, 2020 in New York City. And then a week later, the governor, by executive order, adopted a 3-month eviction moratorium, which put a stop to what was happening in housing court, with the exception of post-eviction cases, which were a priority and which continue to be processed, and also emergency repair and harassment cases, and also illegal lockout cases. But no eviction cases were moving forward as of March 20th until after that 3-month moratorium. And then in the second half of the year, cases began to be permitted to be filed. The court started adopting use of what's called NICEF, which is it's an electronic filing system. And as of the time that cases were allowed to be filed, which I believe was after June 20th, 2020, those filings would most likely be done through a virtual platform. So nobody would have to go to court to file them. Landlords would upload certain documents after serving them in the regular course on tenants. And those cases started. Even though they started, they didn't continue in the same way that they did before the pandemic. So there were a lot of filings with things not being scheduled and kind of being in a holding pattern. During this time, we're going to talk about this a little bit later, but something called the Tenant Safe Harbor Act was passed, which provided protection for tenants who owed arrears during the pandemic from eviction. And because of that law, the court started doing a detailed scrutiny of cases that were pending to make sure that tenants were able to get the benefit of that law, even if their cases started before that law passed. But towards the end of the year, there were some evictions. I believe there were 7 total in New York City in November and December. And those were the first evictions after March 13th, 2020 in that calendar year. And then the next slide is going to show us where we are now. Okay, so this calendar year, on Christmas Eve, the state legislature finally passed a moratorium. That moratorium provided for a 2-month stay of eviction cases, and that was for January and February 2021. The law also provided that tenants could fill out something called a hardship declaration form. This was different from the form that the CDC had in place earlier in the pandemic. The CDC is a federal agency, and that was something that some tenants might have qualified for protection under. But in New York State, the moratorium, hardship declaration form was available with that new law. And so for the first 2 months of the year, cases did not move forward. And then starting March 1st, if a tenant had filled out a hardship declaration form and delivered it to either the court or to their landlord, that was also to stop the case from proceeding. And then originally that was to stop the case through May 1st. That was then extended to August 31st, and it's now been extended to January 15th of next year. So we're still in the protected period. That if a tenant has submitted a hardship declaration form, that is supposed to protect them from an eviction case being filed or moving forward. And the other very important thing that happened in 2021 was the ERAP program, which opened for tenant applications on June 1st. And whether or not someone filed a hardship declaration, by applying for ERAP, tenants are also entitled to protection or a stay from their eviction case moving forward. So that started June 1st, and that program remains open at this time. Okay. Next slide. Thank you. So just to summarize, there is a current eviction moratorium in New York State until January 15th, 2022. And there's still the right to submit a hardship declaration form. If the tenant has not yet done it, they can still do so. And the other thing that the ERAP, some of the laws did was extended the protective period under the Tenant Safe Harbor Act. So when the Tenant Safe Harbor Act was first passed, it said that there was protection from a tenant being evicted for owing rent during the pandemic, which was defined as starting March 7th. And it would have ended when there were no longer restrictions on public gathering. But the legislature decided to extend it. So it's now, that period is extended through the same period as the moratorium, which is January 15th. So we're still in the protected period that if a tenant is in arrears for the period between March 7th, 2020 and January 15th, 2022, they have a potential defense to eviction for any arrears they owe during that time. Okay. There was a little hiccup with the hardship declaration forms that happened in August 2021. Landlords challenged those forms, and that challenge went up to the US Supreme Court, and the Supreme Court said that it was not permitted for the simple act of filing the declaration form to stop the eviction case. There had to be some ability for the landlords to challenge those hardship declaration forms. And so when the state legislature addressed that court challenge, they provided for an opportunity for landlords to challenge them. So just if someone has filed a declaration form and a landlord wishes to contest it, they do have the right to contest it. And that would be done through a court proceeding. And it's important to remember that right to counsel, or the right to get an attorney for tenants in housing court, has been expanded during the pandemic. And so most tenants should be eligible for legal counsel in those proceedings, which is particularly important if a landlord is trying to challenge a hardship declaration form or to move forward with eviction during the pandemic. We touched on this already, but the Safe Harbor Act protects tenants from a possessory judgment or from eviction for arrears that are owed during the pandemic, which is defined between March 7th of 2020 and through January 15th of next year. And then additionally, as we mentioned before, if an ERAP application is filed, that also provides for a stay of a housing court proceeding while the application is pending. And after approval, there are also protections that are in place by virtue of the tenant being approved and the landlord accepting payment under the ERAP program, which we'll touch on a little bit later. So again, I hope everyone on this in this meeting is familiar with ERAP. ERAP was much anticipated and finally opened on June 1st, 2021. And it's a statewide rental assistance program that is potentially available to tenants who owe rent during the pandemic, which they define as March 13th, 2020 to the present. Under ERAP, tenants can qualify for up to 12 months of rent arrears, up to 3 months of future rent after the application is filed if they are rent burdened, meaning they're paying more than 30% of their income towards rent. And if they qualify for rent arrears, they can also potentially qualify for utility arrears of up to 12 months. So it's really a substantial program that can help a lot of people in need who have fallen into arrears during this time. At this point in time, the ERAP fund has been almost fully committed, meaning that most of the funds that were allocated for this program are, the way they put it in the website is, quote, they've been obligated. So that means that tenants have either been approved for payment and that payment has gone out, or they've been provisionally approved and they haven't yet issued the payment. So we have some statistics in a later slide, but the fund is almost fully used. We don't know if more funds may be added, and applications are still open. And so if there's anyone who has not yet applied for ERAP who believes they're eligible, you can still apply and you should apply. There's still protections from just by virtue of filing the application. So we want to encourage anyone who hasn't yet applied to do so. However, at this time, the priority for consideration is in areas outside of New York City, and there was some extra funding adopted for some tenants who were above the income limits under ERAP. So ERAP was targeted towards lower income tenants, and there's additional funds available for tenants at a higher income level, which we're going to see in just a second. So the counties on this screen, which none of them are New York City, do have more of an opportunity for tenants in those areas to be approved for ERAP because they underutilized their allocation. So basically they didn't see applications in the number that they were expecting statewide. So again, as we said, though, New York City tenants should still apply if they believe they're eligible. And the next slide is going to show us those income levels. Okay, so the original version of ERAP targeted, they gave priority to tenants whose incomes were below 60% of the area median income, and the cutoff was 80% of area median income. This extra pot of money that is available allows for applications for families between 80 and 120% of the area median income. So again, we'll be sharing these slides at the end of the presentation, but if you yourself or people you're working with have incomes in these ranges, they can still apply for ERAP. And there's at least some, they're not quite the same amount of funds, but there are funds that are still available. All right, so this is just a rundown of what's happened so far with ERAP. And you guys can read these as well as I can, but there were quite a few applications that were submitted. We broke it down between statewide numbers and numbers for the Bronx. So almost 60,000 applications submitted in the Bronx, over 18,000 approved, 161 million dispersed already for Bronx tenants. If you look on the left, there's 1.8 billion, which has been, quote, obligated, meaning committed or already paid. Of that, less than half has actually been paid. The rest is committed or obligated. So one thing to remember about ERAP is if a tenant is approved and the landlord doesn't complete their portion of the application, the funds are held for 180 days to give the landlord an opportunity to certify their part of the application and to provide information for payment. So we don't know what that's going to look like in the end in terms of whether some funds will be freed up if a landlord doesn't participate in that time frame, and that's because it's 180 days that could potentially delay disbursement of many of these cases. We saw a lot of delay in ERAP when it first started. It has gotten better, but as we can see from these numbers, there's many families who don't yet have an answer to their application, even though the program has been open for more than 3 months. So you know, it was a huge undertaking to administer ERAP. We're very happy and grateful for the families that were approved, but there's many more families who still need that help and that we're hoping will also receive it. All right.
All right. This is my cue, I think.
I think so.
So there are a number of issues that have we've become used to through working with clients and helping them do their applications. So we just wanted to highlight a few here. One of them is if your application can't be verified, we use that terminology to essentially mean that you can't find the application in the system. And that could be that because the applicant or the tenant doesn't have the application number. I think that's more common when someone assisted you in applying. If you have a case manager and they, in the end, didn't give you the application number, or you do have the application number and you put in the birth date as well, but it doesn't show up in the system. So we recommend that you call the OTDA hotline to check if it's in the system. And that number is at the bottom of the screen there. And I think it's at the bottom of many slides that we're going to show you. And if they don't see it in the system, then you would have to do a new application, do it over again. Then another one that's possible is if there's more than one application, so duplicate applications. That's basically when a tenant submits an application while one is already pending. This may be because you weren't sure that the first one was submitted. It was submitted without your knowledge, either by your landlord or someone who was trying to help. But in most cases, the one with the most information is kept active. So the one that's more likely to be approved is kept active, and the one missing more information is denied. That's what usually happens. That's what's supposed to happen, but we recommend that you call OTDA just to make sure that the correct application remains active at the end of that process. So another issue is missing documents. This is probably the most common that I've dealt with personally, which is, a client will text me or email me and say that they got a notice that there are documents missing from their application. Sometimes I've called OTDA and they've said that there actually isn't anything missing, but sometimes there is something missing. So whether it's a lease or a pay stub or something, just make sure that you get exactly what it is and upload it to the application. And then there's always a confirmation number when you upload a document. So maybe you want to make a note of that as well. Then there's the landlord not cooperating. I know that Beth had touched on this in an earlier slide. At certain times, landlords have refused to complete their part of the application, which kind of involves confirming the amount that's owed, providing bank information so that the funds can be transferred electronically directly to the landlord. What the good part is that the tenant is still protected if there's a pending application, even if the landlord is refusing to move forward with it. And even without the landlord's cooperation, the tenant's application can be approved. And then, as Beth was saying, if it is approved without the landlord's cooperation, it's held for 180 days, about 6 months, for them to comply and claim the funds. Then for utility arrears assistance, for those of us, those in this training who have done an application for ERAP probably know very well that the section for utility arrears assistance is very long and involved. If you are looking for help with your Con Edison bill, it's asking for about a year's worth of bills and what the arrears are, where they came from. And perhaps that's why the approval process for the utilities is taking much longer than the rent arrears approvals, but they are considered separately. At this point, we are recommending that people apply directly for HEAP. And I think we're going to provide information about those applications at the end of this. But yeah, it's not entirely clear how best to find out the status of your utility arrears application and what's going to be happening with that on a larger scale. And then at the last one we wanted to just mention is the landlord rental arrears program. So this is where the landlord is actually applying for the arrears, but that's really in kind of the rare circumstances when the tenant has, let's say, moved out to a different apartment while they owed rent arrears, or if the tenant is unavailable for some other reason. Yeah, that application does not offer tenants the same protections. So in all cases, it's better for tenants to apply on their own for ERAP to access those rights and protections. So this is what I was talking about in the earlier slide about verifying an application. So the easiest way, or I guess the most easy visual way, is to check it online. And we have the website down at the bottom here. And this is what it looks like. So the big bold letters, check application status. So you need the application number. That is not a confirmation number. It's a 5-digit combination of letters and numbers that you're given when you first start the application. So it's not shown at the end of the process that can say, you know, this is your confirmation number. And then you need the date of birth of the applicant. You can make an account, but it's not necessary for checking the application or uploading more documents. Just want to mention that you don't have to do that if you don't want. And then you can also check the ERAP status by phone. This is that phone number for OTDA. And they've been very responsive. I think I was picturing it to be kind of another side of calling a job center, but they've actually been answering the phones and been able to access information pretty easily for our clients. And then I guess we've been talking about this in different ways, but these are the protections for pending ERAP applications. So once it's submitted and before you get an answer on it, while it's pending, the eviction cases are stayed. So basically your case can't proceed in housing court. And then during that time, tenants should give their landlords both the application number and their date of birth so that they're able to check the status as well, and also upload their documents to the application itself. Yeah, so they'll need to participate, as we were saying before, with the ERAP application for final approval and payment. And then after the approval, so ERAP satisfies the full rental obligation for the time period covered by ERAP. So basically that means that if you got an ERAP approval for 6 months of rent, that is all the rent that was due for those 6 months. So you later on, your landlord can't go back and claim that during those 6 months that was already paid, there actually is more that you owe. So it doesn't mean that there's no arrears overall anymore. Just that for that time period, that debt is fully taken care of. So that means that the landlord waives late fees for that period. So maybe for those 6 months, you were charged a late fee every month of $10, $15, and it was not paid. Once the ERAP pays those 6 months of rent, those 6 months of late fees is waived. And then also there's to be no rent increase for 1 year. I don't know if we're sure on what exactly this means, because for many tenants who are in rent stabilized housing, as we know, every year, if you chose a 1-year lease, then that following year you'll be offered a renewal. That's your right as a rent stabilized tenant, and it'll have some percentage increase included on the renewal offer. But that's what the ERAP program says, and I think we'll see how it plays out. And then finally, the landlord cannot evict due to an expired lease unless you're in a building with, is it 4 units or fewer in a small building for a year after payment. I know I have a client whose lease expired during the pandemic and she was in housing court, and I've assured her that although she hasn't gotten the renewal lease yet, this is kind of part of the benefit of her ERAP approval.
Maeve, if I can stop you for a second, we had a
Yeah.
question about repeating the first bullet point under the after ERAP approval. If you can just cover that one more time.
Sure. So ERAP satisfies the full rental obligation for the time period covered by ERAP. So essentially, if I can use that same client as an example, she began owing rent from, I would say, December 2019. However, she got an ERAP approval from June of 2020 until May or so of 2021. So for that 12-month period, the ERAP approval from June to May, those months are taken care of. And the landlord can't sue her for that period of rent anymore, but she still owes this rent from before, from December 2019 to May 2020. So they can sue her for that rent that wasn't paid by ERAP, but this section over here, the 12 months of rent that were paid, that's a complete payment. They can't bring her to court over that money. It's hard to talk about. I feel like I keep repeating like the same. It's when you keep saying like her or she or it. It's a little confusing, but hopefully that answered a little bit more.
Thank you.
Yeah. All right. So I wanted to go a little more in depth about ERAP approvals. In terms of how you access the information, you can see that you were approved by checking the status, but it doesn't give you any more information. Then tenants have also gotten text messages that they have been approved, but without other details. And then again, some other tenants have gotten detailed text messages. There will be a letter with full details of approval that are sent to both the landlord and tenant, and that could be either email or mail. I've definitely contacted or been in contact with tenants who found out of their approval and the amount and the time period from their management. So I guess in this time period, we're all kind of sharing information. And then funds are sent directly to landlord by electronic transfer. We just wanted to make sure it was clear that there was no check being physically sent, and just for them to know that it's just going right into the landlord's bank account. And if the tenant is approved for arrears and for also future rent, as you may recall from earlier slides, you can be approved for up to 3 months of future rent. Then that's sent as one lump sum, like all at once to the landlord. Then after you get your approval, you would first request a rent history from your landlord. And these are the 3 steps that I kind of thought were key. Confirm that the money was received and credited to you. Then compare the approval letter with the rent history to make sure that the amounts are the same. And if you did get future rent approved, that amount was included in the sum that was sent to your landlord. So you may have a credit because it would be covering rent in the future. Or if you have more arrears than was paid by ERAP, then you may not have a credit. But that's something to definitely investigate and figure out what your next move is going forward. And then what if you still have a rent balance? And what if you have a pending case in housing court at the time of your approval? So if you still have a rent balance, using that rent history, you can calculate the amount that you still owe, so that you're aware of what it is, and you can start to think about your options of how to get that paid off. And you would confirm that amount with the landlord. A lot of times math, like simple adding and subtracting, seems just that, it seems simple, but it's definitely something that you want to go over with your management. And then apply. So our suggestions are to apply for public benefits that you may be eligible for. such as, I mean, public assistance has a shelter payment included in it. So if you're eligible for that, definitely apply for it. If you're eligible for food stamps, go ahead and apply for that, because then you might be able to spend more money going towards your rent. And then contact community-based organizations for assistance with that to access benefits you may be eligible for, and accessing additional funds from charities. So we may all be familiar with funds from charities. Maybe 1 month of rent can be a big lifesaver to bring you back to a zero balance. So those are kind of our suggestions for if you have a rent balance. And then if you actually are in court, in housing court, not that you were behind in rent, but that you had a date in housing court or have a date coming up, then we want you to check NICEF, which is, as we said, is that state court website. So it includes all case documents and court dates, especially for newer cases, they should all be there. And just look at I put a red box around the section that says either create an account or you can search as a guest. If you want to create an account, that's great, because then you can like log in and save your case and all those things. But it's easier just to search as a guest and use your index number or your first and last name to find your case. So it's just better to know what's been filed in your name and what upcoming court dates you have. So definitely check that if you have a case already. And then this is important to know. If you have a case in housing court, the moratorium is extended until January 15th, 2022. We still recommend that you do a hardship declaration, which entitles the tenant to protection under the moratorium. And most of all, that you have a right to counsel, and the right to counsel has been expanded a lot. So you most likely have a right to counsel. So you would, if you're in court, you would ask a court employee for a referral to a lawyer, or you can call that number, the 718 number. Yeah, ultimately it is helpful to have counsel. So even if you think it's too much trouble or you don't feel like it, or whatever it is, it may really help you out in the end to get a lawyer. Then there are a lot of resources available for tenants to complete the application. And so these are some resources for tenants. That's the OTDA hotline, or a community-based organization in your area. So you see there Bronx Works, NICA, Mosholu Montefiore Community Center. And I think there's one more. Then HRA, home base. Home base, the easiest way to figure out what office you should go to is to call 311, because it's based on what area of the Bronx and the city you're in. Then housing court answers, and our legal clinic will be answering emails that are sent to our email address there, legalclinic@potsbronx.org. POTS case management can assist with accessing public benefits, and then right to counsel attorney line is the bottom number there. I've seen a number of questions pop up. Do we want to go alternate, or how did you want to do that?
Sure. Let me take the first question I saw, which I think had to do with the funding allocation and whether there's a possibility that there'll be additional funds allocated for the city. I don't know the answer to that. I also don't know if additional funds are going to be added to the overall pot of money for EREP. I know the governor is still trying to get more funds. So that's why I also feel like people should continue to apply if they haven't applied already. And we don't know the answer to overall what's going to happen with those funds. But I think the best way, well, if there's a need, people should apply, and hopefully that'll demonstrate the need, and then maybe the funding will follow. I guess that's what I'm thinking. There was a decision at the beginning about which districts were going to be administering ERAP for themselves. So for example, Yonkers administers it for themselves as opposed to others that were allowing it to go through the state. And I think the hope was that if you went through the state, you'd get a potentially greater percentage of arrears. And I think that's been true for New York City. So that's my best answer to that question.
Yeah, and really quick to remind people of how they can ask a question. You can either type out your question in the chat and one of us will read it out loud for someone to answer. Or you can type your name in the chat to let us know that you want to ask a question. And I can unmute you so you can ask your question yourself. If you're on the phone and you can't type in the chat, then you can unmute yourself and just kind of briefly say, I'd like to ask a question, and then wait until we get to your question in the line of stack. Okay.
I also just want to ask if there's any people here from CBOs that are also handling ERAP applications. If there's anything that we didn't cover or any other insight you have that you want to share in this setting, we'd love to hear from you also.
Hi, I'm Jordan Dewberry from BronxWorks. We're one of the ERAP application assistance providers here in the Bronx. And yeah, I think a couple things just as far as applying now, just it's better for you to apply sooner rather than later because not all of the funds have been allocated yet. As far as I'm aware, it's just a lot of them have been. But I'm not sure if New York is going to be getting additional funds from reallocation through the Department of Treasury. That's a request that's been made by the governor. But if that happens, the ERAP applications are being considered first come, first serve. So if you wait, especially now, if you're looking at submitting an application today or tomorrow, or thinking that, oh, I'm busy, maybe I'll get to it in 3 or 4 weeks, you definitely want to try to do that as soon as possible, because that could be the difference between you getting approved or the funds not being there. And obviously the 3 or 4 weeks is just an example. I'm not sure how long it's going to take for this funds. And also about half of the funds that have been allocated have not yet been paid out. So after those 6 months, that may be reabsorbed back into the program, and then folks that were waiting in the queue, it may end up being paid out to them. I'm not exactly sure how it's going to look 6 months from now. And then I think another big one is the utilities. So I think there have been some approvals for utilities. They've been extremely rare right now. The idea is that the rent is more than likely going to be paid off first, and then the utilities will be looked at later. At least that's what we've been hearing. So, if you've submitted something for utilities and haven't heard back yet, it's entirely possible that your utilities will be paid off by ERAP, but it just may be a while. And in the meantime, I think there's a utility shutoff moratorium that expires in December. So definitely start looking at a HEAP application. I believe those benefits start paying in January. And then other than that, if you do need assistance uploading documents or something like that, feel free to reach out to BronxWorks. I can put our hotline and our website information in the chat.
Thank you, Jordan. Yeah, we neglected to share the utility moratorium, I believe, is until December 21st. But Con Edison does have, they are under an obligation to work with folks with a financial hardship even before COVID happened. And so there's a lot of information available on their website, on various government pages. And I think a lot of us are going to be spending a lot of time trying to help tenants get utility arrears assistance to the extent that we can, because of the tremendous need that there is in that area right now. Thank you. Is there anybody else who's wants to share any feedback on ERAP or any other I guess, tricks, suggestions. If you do, please feel free to speak up, and we'll also try to get to the questions.
Hello, I have a question.
Mhm.
Hi. Yes, my question has to do with, okay, so some clients, they are getting served court documents. And then there's a client, she has court on November 3rd already. So I was wondering, why are they placing them in the on the calendar so quickly? So she had to apply for ERAP because she didn't know how to go about it. So she applied yesterday, but she still needs to upload the documents. Sorry about that.
Okay, let me try to answer that. So landlords are allowed to file cases right now. When they file cases, they have to let tenants know of the right to file a hardship declaration, and they're supposed to include the hardship declaration in the court papers. If the tenant doesn't sign and return the hardship declaration, the landlord will go ahead and file that case. And the tenant can still submit the hardship declaration at a later time, but if they do submit the hardship declaration, that should stop the case. However, we want to make sure that tenants don't fail to appear at any court appearance that's being scheduled for them. So in that situation, you should advise the client to keep the appointment. The other thing that may happen at that appointment is they may be offered an attorney. So they're trying very hard to connect all tenants at risk of eviction with available counsel. If the tenant doesn't go, they won't make that connection, and they might have a harder time connecting and getting an attorney to represent them. So we would advise everyone not to miss those appointments, to go, hopefully be offered an attorney, connect with that person. And then what would likely happen is, as long as they provide that update that they've applied for ERAP and or submitted a hardship declaration, the case would be most likely taken off the calendar until after the hardship declaration period, which is after January 15th. So we're already seeing cases adjourned to after that date. So our court dates are piling up in January right now, but there's not a lot that's being scheduled before then, but cases still can be filed.
Okay, thanks so much.
Sure, thank you. Thank you for your question.
I got a
Before
private,
we take,
sorry.
oh, go ahead. Well, I just have like 3 questions that we had gotten throughout the presentation. I want to make sure we don't miss those.
Okay.
And then we'll give, if you want to actually speak and say something more, please type your name in the chat so that we can just respect those who've been waiting to have their question answered. So Maeve, why don't you start with your question, and then I'll go to the 3 questions that are in the chat.
Okay, so I was sent, if the landlord doesn't comply within the 180 days, will he be allowed to sue in non-payment for those funds? If so, will those funds be severed automatically, or will the tenant have to request they be separated under the Safe Harbor Act? So yeah, I meant to say this actually in the slide where I was talking about the landlord's failure to comply, that even if the tenant applies for ERAP and the landlord refuses to submit their documentation and participate in the process, and the tenant actually gets approved without the landlord's involvement, and the money is held for the 180 days, ultimately after the 180 days, that money will no longer be marked for the tenant, right? So what happens to that money if the tenant still owes it and the landlord doesn't have it? So basically that money goes back into the ERAP pot, but the landlord can't sue for that period of rent because essentially they rejected it in this form. And so now they can't put the tenant at risk and sue them for money that they could have had. And if they are sued for non-payment, it would just have to exclude that period of time for which like the ERAP approval was. So I hope that
Maeve, can I
answers
add
the
one
question.
thing to that answer? You're 100% correct. The only thing I will say is that I expect some landlords will sue, even though they're not legally allowed to sue.
Oh, right, yeah, and it'll have to be
And-
a defense, yeah.
Yeah, and so the way the law is written, the state would give the tenant a letter saying they were provisionally approved for the amount, and that letter can be presented to assert the defense that the ERAP money was available for that period, and the landlord is not permitted to get it because they didn't participate in the program. So tenants are still going to have to come to court and defend themselves and keep their documents, and we're going to have to encourage them to do that, and also to be connected to counsel. So hopefully they won't get there won't be a mistake that's made.
If I could jump in on that, one thing that we are encouraging tenants to do also is to send a letter to their landlord via certified mail stating that they applied for ERAP. This was the application number. If they're comfortable with it, what their date of birth is, just so they have a document that they have documentation that they can show in court in future that they did actually notify their landlord, because in theory, the landlord could say, well, you were approved for ERAP, but we never knew you submitted an application.
Yeah, it's a good idea.
Okay, I have 3 questions that I'm going to lump together, or 2 I'm going to lump together and 1 we can handle separately. They are, if you apply for ERAP and you're already approved, but you, for whatever reason, are not able to continue paying rent, and you are now you now owe rent again, can you apply for ERAP again for the months that accrued after your initial approval? And then the second is, can you get a one-shot deal funds and ERAP, or would that be considered double dipping?
I can take the first one if that's okay. So my understanding is and this kind of shocked me, but we've had clients that were told they can apply a second time, even if they were approved for ERAP, that they can apply a second time. To me, I was very surprised to hear OTDA staff advising people that they could apply a second time. But if we imagine that we have a client, let's say, who got 6 months of arrears, and then they owe additional months during the period that will be covered by ERAP afterwards, then I imagine it's possible. I don't know how those applications are going to be treated, but we've been told that that's potentially permitted. However, if you already got 12 months plus 3 months, I would assume you can't reapply. That would be my personal opinion.
I would add, I've had a client who received an approval from ERAP, but was advised by an OTDA staff that she could actually appeal the amount she was approved for to ask them to consider her for more. We have yet to see how that plays out, but that is an option. And does anyone want to take the question about a one-shot deal and getting a one-shot deal in ERAP?
I guess, I mean, I just don't really, I haven't encountered this yet. I know we're talking about, I assume we're talking about one-shot deals for rent arrears as in addition to ERAP. And at some point right before or right after ERAP opened, we were told that all one-shot deal applications will be denied and diverted to ERAP applications. I have heard whispers that one-shot deal applications are open again, but I'm not sure how it works together with ERAP applications. I welcome anyone with experience or information on that to add. I
can just say that as long as you're not asking for the same arrears to be paid twice, it's not double dipping. So if you apply for ERAP for the period covered by ERAP and you get approved, HRA should, and then you want to apply for a one-shot deal from HRA for the other arrears that are also owed, that is perfectly fine. HRA is going to want you to show them documentation about what you applied for and what you were approved for. And it's very helpful if you have that breakdown letter that says, you know, you were approved for 12 months, hypothetically, plus 3 months, and these are the months that were covered. If you owe rent from before that or after that, and you want to apply for a one-shot, you should be eligible, and those applications should be processed by HRA.
Yeah, we have
assuming
a
you meet assuming you meet the other eligibility criteria, because that's the one thing I will say is that ERAP did not have a component of like future ability to pay rent or any of those things. It just had other eligibility requirements. So we're going to have to be able to ensure that clients meet those other eligibility factors for the one-shot deal. Sorry.
I just wanted to say that Yvonne Pena from CSS provided some information for us. That New York City will consider one-shot deal applications if households have been partially approved or denied for ERAP, and HRA does require an ERAP determination before they process the one-shot deal application. Thank you, Yvonne. And then,
all right, the the third question that came up was whether applying for and being approved for ERAP would prevent someone from getting an apartment in the future.
I'm trying to understand the question and how that would impact it. So I guess the question is, if you get government assistance, does that make you less desirable as a tenant? I guess that's how I would understand that question.
Well, let Lisa, I'm sorry, I'm going to pronounce your last name wrong. If you want to unmute yourself and say more about your question, if not, totally fine. We can answer the way that we understand it.
Hello. Yes.
Hi.
Hi, Lisa.
Okay. I don't know. You know how I was reading some stuff on the internet and they always have views and opinions on certain subjects. But when I'm not sure if I was reading it correctly, but I saw something that said, if you get funds from ERAP and you try to go get another apartment, that it will look like you don't have a good reputation to get another apartment. Like, can another landlord look at that and say, no, we don't want you because you had assistance from ERAP, which shows that you couldn't pay your rent?
I mean, I don't see how they would get a hold of that information on their own. They may ask you, but I guess I don't see why they might ask you about, have you ever gotten government grants before to pay your rent? Maybe, I mean,
Are
I
they
think
able to get that information from your landlord?
So I think the information is private. However, one of the things about the public court files is that there is a possibility that somebody who's looking for it could find information about court cases. So landlords and what they call tenant screening places already used public court documents to try to determine if somebody had a history of non-payment, for example. And those are public records. There's always a risk that those public records will get shared or become known. In New York City, it is, we have an anti-discrimination law that includes source of income discrimination. So if someone were to be denied an apartment in New York City because of a past receipt of government benefit when they're eligible for an apartment now, that would be illegal. But we all know things happen sometimes that are illegal and they're hard to address. So I guess what I would say to the question is, I think it's private information. If someone's applying for ERAP, they may have other things that might be on the radar of landlords that are looking for apartments, such as job loss or a history of court proceedings that could potentially become known. But it is private information. It shouldn't be something that's publicly available. And some of the security precautions from the program, they don't, for example, you can't search someone's name and find out if they were approved for ERAP. The only way they would know is if a tenant disclosed it, if it was part of a public court record, or if it is possible a past landlord might share it.
So like in my case, I owe rent, but I haven't been sent to court.
Mm-hmm.
So that would be different, right? Like if I went to court, my information would be in the court records.
Yeah, yes. If you got sued, then the papers would be potentially viewable to others. But I guess what I would say is, if anyone needs ERAP now, I mean, the pandemic has hopefully shifted some of our collective ideas about what it means to need assistance. Everybody in this pandemic needs assistance. There's been tremendous job loss, tremendous hardship, and there's no shame in applying for the benefits that are there. It's there for people who need them because of the tragedy of the pandemic. So I hope we can all help our neighbors not feel that there's a stigma in applying for assistance that's needed for a vital need such as housing.
Okay.
Yeah, and Carla put in the chat, she said that they can run a credit report and they can also find out if there's a dispossessed in the housing court system.
Right, so a
and
credit
I hope we clarified that.
Can I just say something? I'm so sorry.
I was just going to point out that there's a distinction between whether you were applied and was approved for ERAP versus whether you were actually sued and were taken to housing court for an issue with your unit. So yeah, I don't know, Beth, you want to say more?
I just wanted to say a credit report would only pick up a judgment. It wouldn't pick up a housing court proceeding. So if somebody has a judgment against them in housing court, that potentially shows up in a credit report, but applying for a government program wouldn't show up in a credit report.
Okay.
Okay, Maeve, did you have another question that came to you?
Not really. I'm stuck in the credit report stuff on the side here.
Someone shared some resources here. So that's a conversation that we can all continue to have in the community. I mean, the city is trying to address those negative impacts. And I think, like I said, all of us who know about source of income discrimination should encourage our clients and communities to challenge it. And hopefully that that will shift.
Yeah.
And
we do have a question from Shanetta, who asks, how long does it take to receive an answer after you submit an application? She's been waiting since August 9th. We feel you. It's a painful, long process. We actually are just now getting people who we helped apply in June and July. They're just now getting responses from their applications. So, so far it's been taking 2 to 3 months to get a response. So if you've applied in August, yeah, it could take another month to 2 months from this point to hear back. Hopefully you get something back soon, because they have been processing them a lot more quickly since the change in administration. So we cross our fingers for you and hope you hear news soon. But we also encourage people to just make sure that you're checking the status of your application online, which is the website that we showed you, and make sure that you are calling into OTDA to ask if there's anything holding up your application. So do that periodically just to make sure everything is running smoothly.
okay, we're running a little short on time. Do we have time for 1 or 2 more questions if people have them?
Yeah, we have to. I don't see any other questions. Do people have questions they want to have answered now? Okay. If there are no other questions, then I think we'll wrap it up. Oh, did I miss?
Has it been made clear that cold maintenance fees will not be covered under ERAP? That is a question.
Yes, unfortunately, ERAP is for tenants. It is not for shareholders. There might be, I'm sorry, let me just supplement that answer to say there may be other assistance available for people in that situation. But I don't believe ERAP is one of those options. Yeah, and I guess I'd love to just add one more thing if I could, which is again, which like we said at the beginning, this is an extraordinarily challenging time, and is also huge opportunity. So, you know, the Safe Harbor Act is a law that I don't know if any other jurisdiction passed it, but it's going to continue to be available to protect tenants from eviction. And I think it's important that we make sure that everyone is aware of its protections. ERAP did not cover all arrears owed during the pandemic. It did potentially cover a huge amount of some people's arrears, but there's still people who are going to need assistance and protection from eviction. And we're really happy to be in partnership with all of you to try to help make sure people know the information and can protect themselves. And I just want to say thank you to all of you for joining us.
Yes, thank you, everyone.
Sorry,
Thank
Carissa,
you. And we will be, Yep, we'll be sending out an email with the recording of this presentation along with the actual slides and maybe one or two resources, condensed resources that you can use for your organization or for yourself or for other people. So with that, we will say goodbye. Enjoy the rest of your Wednesday.
Thank you, everybody.
Thank you.